Thank you for taking the time to watch this MAATI presentation in which we'll be providing you with answers to some of the most frequently asked election questions we get. This session is in addition to the returning officer videos we've already posted and our returning officer manuals. So if you haven't checked out those resources yet, please do so when you have a chance. The last slide of this presentation includes links to our election resources. And so please take a look at those links and the resources when you have a moment. This session is going to be a review of some of the questions we're routinely hearing from municipalities. And we're also going to be touching on some of the Bill 50 amendments to the Local Authorities Election Act, which we expect will be enforced before the election. Just keep in mind these amendments haven't been passed yet, so we're just talking about what the legislation will look like soon. Also, this isn't a full review of the Bill 50 amendments, so make sure to familiarize yourself with the changes once they're in force. And a disclaimer, this video is intended to provide you with information about some common questions raised by returning officers. This presentation does not provide a comprehensive review of the legislation and is not legal advice. If you have questions about how the legislation applies to specific facts, make sure to get advice from your legal counsel. So here's a quick agenda of the topics we're going to be touching on, and we've organized your questions into these 4 broad topics, and hopefully this is a good way of thinking about how to approach election-related questions in general. So a lot of the questions we get are about procedural matters that might be a bit unclear if you're just quickly looking over the Local Authorities Election Act. And again, the hope here is that we can clarify some of these issues, keeping in mind, of course, that going directly to the legislation itself is always the best place to start. Starting with the Permanent Electors Register. Now, even though we've been working with the amended Local Authorities Election Act since last October, some municipalities are still surprised by this requirement. The important thing to remember is that Section 49 obligates all municipalities to prepare a permanent electors register of residents eligible to vote, primarily using information received from Elections Alberta. Summer villages are excepted from this, unless they intend to offer special ballots or ensure that vouching will be allowed, in which case they will need to have a permanent electors register. What about school boards? Well, school boards do not have to prepare a permanent electors register. School board boundaries are different than municipal boundaries, and Elections Alberta doesn't track school board electors. For those of you conducting joint elections with the school board, this will mean electors will have to complete the Statement of Elector Eligibility portion of the form before being issued a school board ballot, even if they are on the permanent electors register. Which brings us to Form 13. You'll still need to complete the administrative portions of Form 13 for every elector, but if the elector is on the permanent electors register, the Statement of Elector Eligibility portion does not need to be completed, unless they're also being issued a school board ballot. And we understand that this is a little bit complicated, but that is the process that we have with Section 13, or Form 13, I should say. We've also been asked about voters who are not on the register and who may not have been able to register online with Elections Alberta. For example, individuals who may not have access to the internet. In these situations, can a municipal administration help individuals to register with Elections Alberta? The answer is that there's nothing in the Local Authorities Election Act that would prohibit that. So if it's something you think you can facilitate and it's something you're being asked to help with, there's no harm in having electors come into the municipal office to access Elections Alberta's voter link. But municipalities do not register voters themselves. The creation of the Permanent Electors Register begins with data sent by Elections Alberta to municipalities. And to be on the register, voters who have not previously registered with Elections Alberta, for example, by having registered to vote in a provincial election, will need to do that through the voter link process. Alternatively, and this might make sense in most situations, electors who are not on the permanent electors register can simply fill out the Statement of Elector Eligibility on Form 13 and provide ID as required under Section 53, which we'll discuss in a little bit. We've also had some questions about how to record and store information collected on Form 13 on Election Day. So remember that the Permanent Electors Register process also requires municipalities to send elector data collected on Election Day back to Elections Alberta. Section 49 sub 4 of the Act addresses the technical side of data collection, and it states, the Permanent Electors Register may be compiled or revised manually or by means of any computer-based system, and may be kept in printed form or may be stored in any computer-based system or any other information storage device that is capable of reproducing any required information in legible printed form within a reasonable time. Some municipalities are using specialized software for the collection and storage of elector data, but for municipalities that are not using software, Section 49 sub 4 is worded broadly enough that you can use other kinds of electronic collection and storage, like photocopying and scanning, for example. Bill 50 clarifies some ambiguity in the Permanent Electors Register process, especially regarding what the register can be used for and by whom. If passed, Section 49 sub 7.1 will provide that only a returning officer may use a Permanent Electors Register, and only as it relates to the exercise of a power or performance of a duty of a returning officer under this Act. And then subsection 8 will provide, for greater certainty, a candidate, official agent, or scrutineer shall not access or use the Permanent Electors Register, including, without limitation, taking a photograph or making a copy of the register. If you have questions about the Permanent Electors Register process, for example, things about the data sharing agreement, you should contact Elections Alberta. If you have questions about Section 49, the wording, the arrangement, the organization of it, you can give us a call. Moving on to election forms. Election forms can be a bit confusing, but if you sit down and look at them, they become a little bit less mystifying. You'll find that there are some very important forms that you need to use and others that you hopefully will never have to look at. For example, the disclaimer forms, Forms 20 and 21. If you take a close look at the forms, you'll see that they fall into a few discrete categories. And these aren't legislated categories by any means, just a way that I use for understanding them and keeping them organized as I work through them. So starting with the candidate forms, Forms 4, 5, and 26. These should be provided to prospective candidates as part of the nomination package. The next category is the election worker forms. These are Forms 1 and 2, and these should be completed by the returning officer, substitute returning officer, and all election officers as soon as possible, but definitely before they undertake any of their duties. Next, we have the notice forms, Forms 3, 3SV, 7, and 8. These include the Notice of Nomination Day and Notice of Election Day forms. Election forms, these are Forms 9, 10, 13, 13SV, 14, and 17. These include things like the ballot template and instructions for electors. Next, we have the post-election forms, Forms 15, 18, and 19, including things like the election certification and ballot account. Next, the special ballot forms, Forms 22 through 25. And last, the third-party advertiser forms, Forms 27 and 28. As part of your election preparation, you should print multiple copies of all the forms you think you'll need and keep them in a binder that's easily accessible to election workers at the voting station. Modifications can be made to forms if necessary, and the best way to do that is to copy and paste the text of the form from the local authority's election forms regulation into a Word document. Keeping in mind, of course, that these are prescribed forms and you shouldn't be modifying them unless it's absolutely necessary. And if it is absolutely necessary and you do seem to be need to be making substantive changes to these forms, make sure to get legal advice before you do that. Another common question we get, what if I can't open the PDFs on the Municipal Affairs website? Yes, this does seem to be a problem. However, our forms page now includes some instructions on how to open Government of Alberta forms. And essentially what you need to do is download and open them from your desktop. So if you are having problems with these forms, please take a look at these instructions. Remember that as returning officer, your role is supervisory, not investigatory. You're expected to be impartial, and you do not have authority to refuse nominations from candidates whom you suspect to be ineligible. Nevertheless, you need to understand the rules about eligibility in case you get questions from candidates. And that's basically so that you can point them to the relevant sections of the Act and encourage them to review them on their own. Returning officers need to ensure the requirements of sections 27 and 28 are met, and that's really the extent of your screening role. Your municipality's nomination package should include at minimum Forms 4 and 5, and it's also a good idea to include Form 26 and encourage candidates to read Part 5.1 of the Act, especially Section 147.4, which explains the campaign disclosure process. Even though it seems duplicative, the nomination process is separate from the notice of intent provisions, which are outlined in sections 147.22 and 147.221. A prospective candidate who submits a notice of intent will then be able to begin collecting contributions and incurring expenses without having to be nominated. And it's even possible for a prospective candidate to submit a notice of intent and ultimately decide not to seek nomination. However, that could create accounting and disclosure issues if contributions have been accepted and expenses incurred. For most prospective candidates, it will make most sense to submit the nomination papers and notice of intent at the same time, but there is no requirement for this, nor does the Local Authorities Election Act include consequences for failure to submit a notice of intent. There is no prescribed notice of intent form, although we do have something listed as Form 29, which you can use. However, it's not a prescribed form and you're not obligated to use it. So as long as you're collecting the information required by section 147.22 sub 3, you can use your own form. And that might be simpler since the Form 29 we've created needs to be sworn. We often get asked about delegation powers in the context of the receipt of nominations. Understandably, the returning officer will not always be available to review and accept nominations. So having your substitute or a deputy who can do this is a good idea. Remember, before an election worker undertakes any duties, they need to complete the statement in Form 2. Written delegation should be clear and explicit about the precise duties and powers being delegated. If a deputy is being authorized to review and accept nominations, make sure they understand their role and the requirements of sections 27 and 28 of the LAEA. Okay, moving on to our next section, voting procedures. And first, we're going to talk about eligibility to vote in a municipal election. Eligibility is fairly straightforward, but we do get questions like, if I'm a business owner in town but live in the county, can I vote? Or if I have a rental property in the municipality, can I vote? And the answer, of course, is no, you can't vote unless you're a resident. Section 48 sub 1.1 explains how residency is designated for the purposes of the LAEA, especially for those who have more than one residence. Designation in these cases is based on 3 factors in order of priority. The first is the address shown on the person's driver's license or other Government of Alberta ID. Next, the address to which the person's income tax correspondence is addressed and delivered. And then lastly, the address to which the person's mail is addressed and delivered. For summer villages, the added bit of complexity is that non-resident property owners and their spouses can vote. And yes, full-time resident renters in a summer village are also eligible. So how do electors prove eligibility? The answers to all of your proof of elector eligibility questions are in section 53. Now, section 53 and the effect of the permanent electors register has made proving eligibility a bit more complicated. We were hopeful that the permanent electors register would mean that Form 13 would not be needed for electors named on the register. But the form is used to collect more than just the statement of elector eligibility. If you look at the form, you'll see there are several administrative portions that need to be completed every time a ballot is issued. For example, contact info for your FOIP person at the top, details about where the election is being held below that, and then there's a box to track the ballots issued. And on the second page, the deputy returning officer portion and the elector who is unable to vote in the usual manner section. And we have received some more specific questions about section 53. For example, what if a voter is on the permanent electors register but does not have photo ID? In this situation, since the voter does not meet the requirements for proving eligibility under section 53 sub 1 sub a, they would be obligated to go through the section 53 1b process. They will have to complete the statement of elector eligibility and produce one piece of ID authorized by Elections Alberta, which leads to another section 53 question we've been getting. Can voters who are not on the permanent electors register simply complete the statement of elector eligibility and produce just one piece of non-photo ID authorized by Elections Alberta? While it might seem counterintuitive that voters in these situations do not have to provide photo ID, the answer is yes. Given the wording of sections 53 sub 1 sub b and 53 sub 3, this seems to be the effect. But keep in mind that it's highly unlikely you're going to get people trying to vote illegally. And all voters who complete the statement of eligibility are faced with bold, uppercase letters stating, "It is an offense to sign a false statement." You can put a lot of weight on that statement because ultimately it's the voter who is confirming their eligibility. And if they meet the requirements, you are neither authorized nor obligated to look into the matter any further. Some more questions about eligibility and vouching. So first of all, please note that not all forms of ID listed by Elections Alberta will be acceptable for local elections. Only the ones that show both a name and current address may be used. Vouching is still permitted pursuant to section 53 sub 4 and 53 sub 7. However, vouching is only permitted for establishing an elector's address, not their identity. To vouch for someone, the person vouching will need to first have proven their eligibility pursuant to section 53 sub 3 and make a statement in the prescribed form that the elector knows the person being vouched for, knows the person lives at the address indicated on the person's statement, and the person vouching has not been vouched for him or herself. Additionally, the person vouching will need to be on the permanent electors register. This next part of the presentation is a collection of questions that come up with respect to candidates. With the nomination period beginning on January 1st, 2025, I know many municipalities have been getting all kinds of interesting and perplexing questions from candidates. So we'll talk a little bit about how to deal with that. Of course, returning officers have a tough job. Even if you have experience as a returning officer, you only get to do this every 4 years, or if you have a council vacancy and have to do a by-election. So getting bombarded with technical questions from a bunch of needy candidates can be stressful. But don't forget, your role isn't to solve every problem a candidate brings to you. Candidates have responsibilities and need to do some work themselves. Remember, these are people who want to be on council. They theoretically want to do a bunch of complicated and technical work, basically for free in a lot of municipalities. And that work actually starts right away. From the moment a prospective candidate picks up a nomination package. If they can't do some work now, they're going to be in for a rough ride if they are elected. So don't feel bad if you can't give candidates all the advice they're demanding from you. And remember as well that candidates swear an oath on Form 4, which I'm going to read to you in part. The oath is this: I solemnly swear that I am eligible under sections 21 and 47 and section 12 in the case of summer villages of the Local Authorities Election Act. I'm not otherwise disqualified under section 22, 23, or 23.1 of the Local Authorities Election Act. I will accept the office if elected. I have read sections 12, 21, 22, 23, 23.1, 27, 28, 47, 68.1, and 151, and Part 5.1 of the Local Authorities Election Act. The electors who have signed this nomination paper are eligible to vote in accordance with the Local Authorities Election Act. So you can see, even from the beginning of filing a nomination paper, candidates have to do a fair bit of homework. And again, that starts from the moment that they submit their nomination papers and swear the oath. So don't feel bad about reminding them of their obligations and sending them to the legislation and municipal affairs resources for answers. You should not be giving tailored advice to specific or technical questions. Your role as an official is to remain neutral. The most you need to do is point out the relevant sections of the LAEA. The overall responsibility for figuring this stuff out is ultimately on the candidate. And yes, by all means, if you need to get someone off your case, don't hesitate to send them to us. When and how can a candidate withdraw their nomination? So the answer to this is in section 32, but keep in mind this is being amended by Bill 50. So after the nomination period, section 32 currently only allows candidate withdrawals within 24 hours of the close of nominations, if more than the required number of candidates for any particular office are nominated. If the Bill's 50 provisions are passed as drafted for section 32, that condition will be removed, and any candidate will be allowed to withdraw within 24 hours of the close of nominations, even if that will result in acclamations or insufficient nominations. And there are some good practical reasons for that, and some of you may have been in this situation. For example, you don't want to be in a situation where you're possibly going to be electing someone who doesn't want to be on council and is going to resign right away. So this provision is meant to address that. In this last part of the presentation, we're going to talk about counting and handling ballots and some miscellaneous post-vote issues you need to be aware of. And first, we'll start with counting ballots. Votes are to be counted immediately after the close of the voting station by the presiding deputy in the presence of at least one other election official. Either the candidate or their official agent or a scrutineer may be present, but only one of those may be present. So campaigns can't have a team at the voting station for the vote count. Centralized counting is allowed, but only for the advance vote, special ballot, and institutional ballot boxes. And this is only permissible if a bylaw has been passed by June 30th, allowing for a counting center. The LAEA does not allow for ballots to be counted in a single location. Instead, as we've seen with Section 85, ballots are to be counted at the voting station as soon as the station closes. Ballot counting is time-consuming, and you need to familiarize yourself in advance with the rules, especially the rules around the ballot account in Section 88 using Form 19, how to arrange your ballots into packets pursuant to Section 91, how to seal and label your packets as required by Section 92, and how to secure and deliver your ballot boxes and other election materials pursuant to Sections 93 and 94. The returning officer may publish unofficial results as the results are received from voting stations. The returning officer, however, shall, at 12 noon on the fourth day after Election Day, declare the election results. Let's talk a little bit about recount procedures as well. So we don't have time to get into the Bill 50 amendments in any detail, but you should be aware that the recount provisions are being amended. So make sure that you review these sections before Election Day, and again, before conducting a recount if you have to do that. So there are two kinds of recounts. The first is initiated by the returning officer if a candidate, official agent, or scrutineer shows grounds that the returning officer considers reasonable for alleging that the record of the result of the count at any voting station is inaccurate. Next, if the returning officer considers that the number of valid ballots objected to or rejected ballots other than those on which no vote was cast was sufficient to affect the result of the election. Or if the returning officer is of the opinion that there may have been an administrative or technical error that may have caused an error in the count of votes. An application for this first kind of recount must be made within 44 hours of the close of voting stations. For the second kind of recount, the returning officer shall conduct it if they received an application from the candidate who is the runner-up or their official agent. And this is only in situations where the result is within 0.5% of the ballots received by the candidate with the highest number of votes. Applications for this kind of recount must be made within 72 hours after the statement of results is announced or posted. That 72-hour period is also a new requirement under Bill 50. So the timelines and processes for recounts and applications for recounts are strict. If you do need to conduct a recount, make sure to review the provisions of the Act and review them thoroughly and get advice if you need it. A quick note on judicial recounts. At any time within 19 days after the close of voting stations, an elector may apply to the court for a recount. The elector must file an affidavit alleging reasonable grounds for believing the ballots were improperly counted and deposit $300 as security for costs and expenses. And lastly, another thing that you need to remember after the close of voting and once you have a new council elected is that all municipalities need to be aware of these new mandatory councillor training provisions in section 201.1 of the MGA. And this is required for all councillors, including those who have been re-elected. And there are two components to the training. The first is to be held prior to or on the same day as the first organizational meeting following a general election. And this first bucket of training topics includes things like the role of municipalities in Alberta, municipal organization and function, roles and responsibilities of council and councillors, roles and responsibilities of the chief administrative officer and staff. The second set of training topics have to be covered prior to or on the same day as the first regularly scheduled council meeting. But this training can be postponed by resolution for up to 90 days. The topics here that need to be covered include key municipal plans, policies, and projects, budgeting and financial administration, and public participation. Once again, thank you for taking the time to review these questions with us, and thanks to those of you who did send in questions. If you do have lingering questions, feel free to contact Municipal Advisory at any time. And here's a list of the resources that you may use. So again, if you haven't reviewed our additional election resources online, please do so. And again, if you have questions about school board elections, please contact Alberta Education. Make sure also to get updated versions of the MGA and LAEA, and these can be accessed or ordered through the King's printer. If you have questions about the elections database, those can be sent to our information services team.